Good morning, everyone, and welcome to today's Allowable Ex Parte. I'm going to ask Mr. Melchers to read the docket.
Thank you, Mr. Chairman. Commissioners, we're here pursuant to a notice of request for allowable ex parte briefing scheduled for today, June 26, here in the Commission hearing room. The person or party requesting the briefing is James H. Golden, representing Johnson Development Associates, Inc., and the subject matter to be discussed today at the briefing is Johnson Development Associates and H3659. Thank you, Mr. Chairman.
Thank you. Mr. Bateman, I think you have some words for us about rules.
Good morning, Mr. Chairman, members of the Commission. My name is Andrew Bateman, and I'm counsel for the Office of Regulatory Staff, and I'm here as the designee for the Executive Director of the Office of Regulatory Staff at this allowable ex parte. As the ORS representative, it is my duty to certify the record of this proceeding to the Chief Clerk of the PSC within 72 hours that this briefing was conducted in compliance with the provisions of South Carolina Code annotated section 58-3-260, subsection C. That statute sets forth certain parameters and rules under which this briefing must take place, and if you'll indulge me, I'd like to go over a few of those. The requirements of that statute are, in part, that the allowable ex parte be confined to the subject matter which was noticed. In this case, the issue noticed was Johnson Development Associates and H3659. I therefore ask that everyone here please refrain from discussing any matters not related to that subject matter. Second, the statute prohibits any participants, commissioners, or commission staff from requesting or giving any commitment, predetermination, or prediction regarding any action by any commissioner as to any ultimate or penultimate issue which either is or is likely to come before this commission. Third, I'd ask that the participants, commissioners, and staff refrain from referencing any articles, reports, statutes, or documents of any kind that are not included in today's presentation to prevent the need for myself or the company's lawyers from having to try to track down copies or links to these documents to include in the record. As none of the information contained in the presentation appears to have been marked or requested to be granted confidentiality, I'd ask that the presenters refrain from referencing or discussing any materials over which they'd like to maintain confidentiality. And would ask that the commissioners please be understanding if the presenters decline to provide such information to any commission questions here today. Finally, if I've counted my days correctly, material corresponding to today's proceeding will be posted on the Commission's website at the end of the day next Tuesday. Any document referenced or utilized today should be included in that posting. As a final note, please make sure to read, sign, and return the form which you were given at the door when you came in today. Please read the form. This form needs to be signed by each attendee to certify the requirements contained in South Carolina Code annotated section 58-3-260, subsection C, have been complied with at the presentation here today. This concludes my preliminary matters. Thank you, Mr. Chairman.
Thank you, sir. Mr. Golden, Mr. Wesson, thank you. We're glad you're here. Welcome, and we will turn it over to you.
Mr. Chairman, I appreciate y'all gathering this morning. I know you didn't have to come in, and I certainly am mindful of that. I'm Jamie Golden. I'm an attorney here in Columbia with the law firm of Nelson Mullins, Riley, and Scarborough. It's certainly good to always be before y'all again. Before we formally get started, I do want to thank Jocelyn Boyd, Joseph Melchers, Ms. Wheat, other commission staff, Andrew, and the Office of Regulatory Staff, because it is a burden on everyone and more work for everyone, but it does serve an important purpose. Today I'm here on behalf of Johnson Development Associates out of Spartanburg. I have accompanying me today Mark Wesson, who is the president of the Natural Resources Division for Johnson Development Associates. We're here to introduce you to Johnson Development. Some of you may be familiar with it, but we want to go into some of the divisions and what it is that we do. We look forward to sharing with you a history of the company, a history of the founder of the company, and what it is that the company does. Furthermore, we want to discuss a little bit about what we see as the potential under H3659 and South Carolina's energy future under the Act. Again, I'll reference H3659. We also know it as Act 62 of 2019 now. No confusion, but they're interchangeable. We're here to give our interpretations and opinions on the Act. We were intimately involved in the drafting of the Act. Johnson has been working with various stakeholders for the last couple of years, and the ORS, as you have previously heard in Ex Parte, did an excellent job over the last now 14 months getting a stakeholder process together. We feel that Act 62 is a product of that. And I know that my friends at the Solar Business Alliance gave a very thorough and technical ex parte, allowable ex parte to you all. Somebody had to plow that ground. We just hope to provide a little color, a little background maybe on the players involved, the supporters, the advocates of it, and then highlight a few key provisions and take questions from you all if you have any. And without anything further, I'd like to turn it over to Mr. Wesson to give a little overview of Johnson Development.
Thank you, Jamie. Thank you all for coming this morning and having us. We appreciate the opportunity to tell you a little bit about Johnson Development and its history and our perspective on the Energy Freedom Act. The Johnson Group is a family-owned group of companies based in Spartanburg, South Carolina, founded by George Dean Johnson, Jr. The Johnson Group consists of Johnson Development Associates, which sometimes I may refer to as JDA, OTO Development, and American Credit Acceptance. Together, we have just under 3,500 employees, with about 1,000 of them located in South Carolina. On the left side of the screen is Johnson Development Associates. JDA specializes in commercial real estate development. Next is OTO Development, where we develop, own, and manage select service hotels. And thirdly is American Credit Acceptance, which is an automobile finance company working with the nation's top-tier auto retailers like CarMax and AutoNation. Next slide. Here's a little timeline of the Johnson Group. The history of the Johnson Group dates back to 1985 when George started franchising Blockbuster video stores in the Carolinas. By 1993, he developed several hundred stores from Texas to Virginia. In 1986, George started Johnson Development Associates, and it was mainly focused on developing grocery store anchored retail centers in Spartanburg County. I'll talk in more in depth on JDA on the following slides. In 1994, George started Extended Stay America and took it public the following year. After developing 475 hotels, Extended Stay America was sold to the Blackstone Group in 2004. In 1997, George co-founded Advance America and grew the company from a few stores in the Southeast to one of the nation's largest consumer lending companies, ultimately taking that company public in 2004. Also in 2004, George founded OTO Development to develop and manage select service hotels. It has developed over 70 properties under the Marriott, Hilton, and Hyatt brands. The Johnson Group currently owns 21 hotels and manages another 40 in places like Washington, D.C., New York, Los Angeles, San Francisco, Charleston, Chapel Hill. In 2007, George founded American Credit Acceptance to provide financing to the customers of the nation's top automotive dealers. This is a little bit about Johnson Development itself. We do business in 17 states. As I mentioned, it was founded in 1986, focusing on grocery store development in Spartanburg County. Over time, we began developing industrial buildings and apartments in the Spartanburg area. Today, we develop industrial distribution facilities, apartments, and self-storage facilities across the U.S. In addition to those activities, through our Natural Resources Division, we develop utility-scale solar farms in South Carolina. Here are some examples of what JDA develops today. On the top left is a distribution facility we built for Amazon. JDA has built 4 facilities for Amazon, with some of them being over 1 million square feet. In addition to Amazon, we built facilities for names like Walmart, Rite Aid, and FedEx in South Carolina, Texas, Alabama, Virginia, and Florida. On the top right is an example of one of our self-storage facilities. Our projects are third-party managed by CubeSpark, Extra Space, and Life Storage, and tend to look more like office buildings than storage facilities. We've completed projects in South Carolina, North Carolina, Virginia, Florida, Washington, D.C., California, Washington State, and New York. In the lower left corner is an example of an apartment building we recently built in Seattle, Washington. We built apartments in several states, including South Carolina, Virginia, Maryland, Florida, and California. In the lower right corner is our Natural Resources Division. The Johnson family owns several thousand acres of timberland in South Carolina, and we manage it as pine forests, selling pulpwood to be made into paper and tissue products, and saw timber for lumber. The timber holdings were the genesis of the solar development, as utility-scale solar farms can require significant acreage. Some of our timberlands have utility infrastructure, meaning power lines, on them, and that makes them prime locations for large solar farms. So here's a look at JDA's pipeline. We have over 730 megawatts of projects in the queues of Duke, Dominion, and Santee Cooper. Our pipeline breaks down with 323 megawatts in Duke territory, and that's all in DEC. We have 89 megawatts in Dominion and 325 megawatts in Santee Cooper. Our projects range in size from 2 megawatts, which take up about 15 acres, to 75 megawatts, and those can be up to 600 acres in size. Our pipeline represents an aggregate project investment of more than $950 million. To give a sense of scale, a single 75 megawatt project can cost upwards of $80 million to construct. We have 7 75 megawatt projects in our pipeline. These projects will provide energy for 40 plus years. Utility scale solar development tends to happen in rural areas as it requires large tracts of land. An ancillary benefit of solar farm development is the increase in property tax revenue the host county receives. These large tracts of land are typically being used for agricultural purposes and therefore pay property taxes at the very low ag use rates available to them. When a solar farm is developed on this property, the resulting increase in property taxes can easily be 100 times larger than the revenue the ag use rates produced. As an added benefit, unlike most other types of development, a solar farm does not require new schools, roads, water, sewer, or public safety services. Now I'd like to turn it back to Jamie to discuss our perspective on what we believe are some of the more important parts of the Energy Freedom Act.
Members of the Commission, I have the pleasure not only of representing JDA today, but also giving a presentation on parts of the Energy Freedom Act. As you know, H3659 represents a monumental shift in our state's energy policy. There were 50 members of the House that co-sponsored this bill. The leaders on energy policy were all sponsors. If you'll notice, we've highlighted that all 3 House PERC members were co-sponsors. We've also noted the committee chairs that were also co-sponsors of the bill. You will see that House leadership, and for that matter, Senate leadership, wanted this and wanted it to be enacted properly. And we'll get to the vote tallies in a second, but I think it's important to talk about that the business community really rallied around and drove this legislation for the first time. As you can see here, and this is an example of the Senate letter that was sent by about 36 of South Carolina's most prominent businesses and business leaders to the South Carolina Senate, to Senator Rankin's Judiciary Committee. And on this letter, you see the logos, they want solar in the generation mix. But more importantly, their customers demand it. They are now getting questions about products made here, what the gen mix is, from their end user consumer. We as a state do an excellent job of economic development, and we pride ourselves on South Carolina made products. We do a great job of touting that we are open for business. We must increase the renewables in the gen mix, in my opinion, for us to be competitive and remain competitive from a business development standpoint. I alluded to it earlier, but there was not a single dissenting vote recorded on this act. It came over unanimously, and y'all know as well as I do, working with the legislature, how hard it is to get 100 and it looked like a few House members were not present or excused, but I mean, you look at that to find without a single dissenting vote, that's just unheard of. So I think it really goes forward with kind of the mandate that's been sent over. I'll highlight a few key passages, and I want to let you know that it is my opinion that the most powerful section of this entire act comes in 584120 sub F. It is a new day in South Carolina, not to borrow on a phrase or steal from a phrase from our former governor, but it is a new day in South Carolina, and it is now explicitly the state's policy of encouraging renewable energy. I believe that this is the most important piece of consumer energy legislation since 2004 with Act 175 when the Commission and ORS were bifurcated. Simply put, the old way of doing things, in my opinion, are no more. Here is the legal citation and text for Section 584120 sub A and the legal citation to the docket number 2019-176-E. I think this piece is particularly important, and I believe the Solar Business Alliance touched on it, but I would like to go into it a little bit further, because for the first time that I can remember, and I've been involved with most of you all for the last decade on energy law and policy in this state, this is the first time the legislature has ever given you fully funded tools to retain a third-party expert to verify what data is coming in from the utilities. The legislature wants you to fully vet that, and they want to make sure that the information that is given to you, to parties under proper confidentiality agreements, is accurate and truthful. This is a huge win for consumers and for independent power producers. The language reads that the Commission shall engage for each utility a qualified independent third party to submit a report that includes the third party's independently derived conclusions as to that third party's opinion of each utility's calculation of avoided cost for purposes of proceedings conducted to this section. Furthermore, and I don't have it on the slide, but that section goes on to read that that expert must submit a statement in its report assessing the level of cooperation received from the utility during development of the report and whether there were any material information requests that were not adequately fulfilled by the electrical utility. The electrical utilities can no longer withhold information from the Commission without facing scrutiny. The single biggest issue in JDA's opinion facing independent power producers, which stifles development of renewable energy in South Carolina, is unreasonable terms of power purchase agreements. This act requires that the terms and conditions for the PPAs be commercially reasonable. I will defer to Mark to elaborate on commercially reasonable terms.
Thank you. Here's what we believe is meant by the phrase commercially reasonable terms. Commercially reasonable terms are obtained through good faith efforts by willing participants to achieve a common business purpose. Commercially reasonable terms should not include any material, financial, or other concession as a prerequisite. The key components are the process involves willing participants attempting to achieve a common business purpose. They result from a collaborative effort. Also as important as what comprise commercially reasonable terms is what they do not include, such as material, financial, or other concessions as a prerequisite. There are many aspects of a PPA that fall into the category of terms and conditions. We believe one of the most important is the contract length. I'll close with some comments on the importance of the PPA contract length. The length of a PPA tends to have a direct correlation to the length of time over which lenders offer to finance solar projects. Loan underwriting in general looks to identify how the full amount of a loan will be paid back. In the case of a solar farm, that is the PPA, the right to receive payment for the production of energy for a specified period of time. Lenders want to have visibility as to how the full loan will be repaid and therefore tend to underwrite loans to avoid unpaid balances at the end of the loan. Lenders therefore look to the length of the PPA when establishing the duration of the loan they will offer. The next slide is an example of how significant the duration of a loan is to the size of the payment required to fully pay off that loan during its term. So we tried to come up with something that would be familiar to most people. This example uses a traditional residential mortgage of 30 years with a 4% interest rate. For each $100,000 borrowed, it would take annual payments of about $5,700 to pay off the loan. If, however, the loan were required to be paid in 10 years, the payments would be twice as much. If the loan was required to be paid off in 5 years, the payments would be 4 times as much. The point of this example is to illustrate how significant loan duration, and by association, PPA contract length, is to the viability of project financing. This linkage between the PPA length and the viability of available financing, we believe, is why the legislature explicitly directed the PSC to consider the benefits of terms with a longer duration to promote the state's policy of encouraging renewable energy. That concludes our prepared remarks. We'd be happy to answer any questions you may have.
Thank you. Commissioners, questions? Commissioner Urban.
Thank you, Mr. Chairman. Gentlemen, good morning. Good
Morning, Commissioner.
You have obviously been dealing with this for a while, and so I'm hypothetically speaking, in a power purchase agreement, what is the typical duration in the states that have been using these documents? Is there kind of a standard or
So previously in South Carolina, Duke Energy would only offer a 5-year PPA. Nothing's getting done. I think we've seen in Dominion has gone with 20 years, but the avoided cost is so low, it's hard to get anything done. Some of the co-ops that I'm familiar with are putting out 30-year PPA terms. Around the country, we did a kind of a survey, and the legislature was unique here. I think in this act, they set 10 years as the floor, bare minimum in there, and that's NH 3659. But then they have put in there, you know, that longer terms can be granted that we propose as interveners. I know in Montana, for example, they have 25 years on the books. They recently enacted a law at the commission that put it at 15, and their court struck that down, said that's not commercially reasonable, and it violates PURPA. Again, PURPA, the implementation at the state level requires a fixed price and a fixed term to make these viable. And again, you know, in North Carolina, what were they before they what was it?
I believe it's 15.
15 in North Carolina. It's kind of, I mean, that gives a flavor for it. Not to hide anything, I do think Alabama might have one shorter than 5 years. Nothing's getting done. Nobody's sued yet that's in violation of PURPA. But I think that's certainly being talked about. You just, I mean, you can't, So I guess that's a way of saying that it's all over the board as to where these term of lengths fall, and the legislature wants you all to make that determination, in my opinion.
Would that determination be made on a case-by-case basis?
My thought would be that I believe the way the statute reads is for the interveners to propose the PPA terms, but it's really hard, and I don't want to get into anything, that may be pending, but it's really hard to say that anything other than the rate is utility specific. So does that answer your question?
Well, I think so. I'm trying to think of, you used in your slide presentation, the residential mortgage model is kind of something to think about. And so I guess the first question, we're all familiar with that market. Is there and you can get mortgages obviously for 10, 15, 25, 30 years. Do the lenders typically, do they amortize the loan over the life of the agreement? Is that essentially what they're doing?
Yes, that is essentially what.
But do they require upfront down payment as well?
It's more of there's a couple of different metrics from the underwriting. There's a loan to value and a debt service coverage calculation that sort of constrain the amount that will be loaned. But those two are very difficult to meet if, say, in the case of Duke, you only have a 5-year window to do
Right. So obviously, the concept being the longer the term, the lower the payment.
Yes.
And that makes it more commercially viable in certain circumstances.
Correct, yes.
And Commissioner, to that point, I do think the smaller projects are able to avail themselves of a 10-year PPA
Right.
and get something done.
Right.
For the 75 megawatt type projects, which were Mark referenced, that's, in excess of $80 million.
Right. It would be analogous to, you're going to buy a 1,500 square foot home, or you're going to buy, a multi-million-dollar mansion. You're going to have different considerations. That's why I asked earlier, if a project is a large, substantially in scope, a larger project, are you saying that would justify a longer term, perhaps?
Yes, to that point, and I now have clarity on that, yes, I do think that would certainly warrant, be a consideration for a longer term. That's a benefit of a longer term. So, excess of 20 megawatts, whatever that is that you come up with, just throwing out a hypothetical, that would be a reason for a longer term PPA.
Are you aware in other states, have they tied the term length to number of megawatts being produced? Is that typically done or not?
I don't believe I've seen that. No, sir.
Okay. So, have any states tied it to the total cost of the project? Have they attempted to do it in that fashion?
I've not seen that either.
And I think when we say that, we haven't seen it in statute or commission orders around the PUCs around the country.
So, as you read Section 584120I, is it your interpretation of the new law that the independent third-party expert that the commission hires has the authority to ask the company, the utility, for specific request as it relates to their proposal? In other words, they have that kind of a fact-finding role. Is that your understanding?
I think it's explicit in there that with leave of the commission or permission of the commission, that they are entitled to any documents subject to confidentiality of the utility to formulate their opinion on any of the issues with which they're charged.
And if So it seems to me, just when you read the statute, it's fairly clear then, it's very clear that the third-party expert that we employ to help us with technical issues and in an application of the new act has that not only the authority but the responsibility to ask questions of the utility if needed.
It is.
I believe they're required to independently derive their own conclusions.
Their own conclusions. So I don't see it I didn't hear it in the statute, and I don't think I've read it a couple of times. I don't recall, but is it clear to you that the commission has the ultimate say, though? I mean, this is a report that comes to us, a recommendation.
I don't think due process would allow the delegation otherwise. I think
Right.
it's my opinion, and in the drafting of it, that it is their role to advise you, to be able to advise you on a methodology, multiple methodologies, a rate for each utility, their opinion of that. But you're not ceding your authority.
We're not bound by it. It's intended to assist the commission
That's right.
in coming up with a just, a fair, reasonable outcome.
Commissioner Irvin, as a former public employee, I understand limited resources, and I think that was the ultimate wisdom of the General Assembly, is to give someone outside, because we know that commission staff is overworked. This is what that is. It is an advisory role, and they have to issue a report with their independent conclusions, but you certainly are not bound by that.
Right. It's intended to be another tool in the toolbox, so to speak, for the commission to utilize to come up with a best result or a good outcome.
I believe the actual language is any conclusions based on the evidence in the record and included in the report are intended to be used by the commission along with all other evidence submitted during the proceeding to inform its ultimate decision setting the avoided cost for each electrical unit.
Correct. And so along those lines, you all will live with this act, I guess, in the process of its passage. There's a lot of debate, subcommittee hearings, committee hearings, that kind of thing. Based on your understanding of the legislative history, do you think the act contemplates that third-party independent expert would testify at the hearing and be subject to cross-examination, or just submit a report?
In our discussions, in public discussions, I do not recall whether actual testimony and subject to cross was there. I think the thought, my opinion is that the thought was that was a technical advisor to give you a report. They have to produce a report. The report is considered with the rest of the evidence. I don't recall that ever being, their duty, the duty that's in here, and it says it explicitly, is to you, the commission, not
Right.
as an expert. And so I don't see it the same way I do the experts that we all will retain. And I think in the drafting, that was probably the way that the legislature intended.
Thank you. Those are my questions.
Thank you, Commissioner.
Thank you. Commissioner Williams.
Thank you, Mr. Chairman, Mr. Golden, Mr. Weston. Thank you for being here today. I've thoroughly enjoyed your presentation and appreciate your time. A couple of questions. I want to go back to Section 58-41-20 sub I. Commissioner Irving was just referencing that section. I want to talk about avoided costs. Do you think, and this is for both of you, do you think that the calculation of avoided costs is an inherently adversarial process?
As to the cost, not the methodology?
Both.
In a vacuum, avoided cost is just what it should be, what is not incurred in that next purchase. And I don't think it should be. I don't. But experience shows that it typically is.
And that's where I get a little confused. I hate to jump around, but if you go to section 58-41-20 sub F, you reference, Mr. Golden, that this is the most powerful portion of the bill, using the former governor's famous phrase, "It's a new day in South Carolina." The state is seeking to promote the state's policy of encouraging renewable energy. It seems as if to me that despite what method you use, the calculation of avoidant costs should essentially speak for itself. It shouldn't be any gamesmanship employed. It should really just be a mathematical equation that may change based on the utility. So I'm just concerned that I'm hoping it's something that we're not missing, because it seems to me, in my experience, and maybe you have the same experience, that parties can get a bit defensive when discussing avoided costs and the methodology of reaching that number.
Commissioner Williams, we like to say numbers don't lie, but I don't think that's always the truth. And so I think that's where there's some defense, is on transparency, on are you getting the proper information. To that section you referenced, though, that's talking about the term of length of the tenor of the contract, not the rate. So I just want to clarify it's not, so that section is specific to it, but the language is not. It is now the policy of this state to promote or encourage renewable energy. We've never had that codified before.
And if the avoided, and not to interrupt you, but if the avoided cost is too low, that does not encourage renewable energy, does it?
No, it stifles.
So it seems to me that we have to figure out a way to bring transparency to calculating avoided costs. It shouldn't be too hard for anyone, arguably, to understand how those costs are calculated.
So I think in this act, it explicitly says that the methodologies and formulas and all information shall be transparent in that process. You get your methodology, and then you calculate the number, and that's how we argue over it. I mean, that's what's in 3659, in my opinion.
Do you think that there should be more than one method used, or should there be some standardization?
You know, on that, it's hard to know, because we've never been given that option before. We certainly are going to bring people before you, experts that do have experience on that, that will give their opinion of it, and that'll be far down the road. Personally, it's kind of hard to defend multiple methodologies for one state, and I don't know if that's good or bad for my clients, but I do think that a state approach is something that this act allows you to consider. I know it allows you to consider that.
Thank you, gentlemen. Mr. Weston, if you have any comments, you're welcome to give them. I didn't mean to limit my discussion with Mr. Golden. If not, I'm finished. Thank you, Mr. Chairman.
Thank you. Commissioner Howard.
Couple of quick questions. Is there any relationship between the length of the terms and depreciation of the asset?
There is no correlation between the two. The assets, as I mentioned, will produce energy beyond 40 years.
So when you depreciate, say, the solar panels, you're using a 40-year depreciation? Or what year?
No, I was talking about the life of the useful life. If you were to depreciate the panels, you would look at the useful life from a gap perspective.
How long would be the useful life, you would say?
Probably 40 years, something like that.
One concern I have is because this industry, particularly electric industry, is moving so fast and so rapid with technology. Is it any concern, should we offer any concern when we talk about depreciation as to the current solar panels being obsolete in so many years, 5 years, the technology, there can be technology there to make these panels obsolete, and would that play into the terms?
Well, the panels themselves, while at any point in time there may be a more efficient panel that could go on the next solar array, the ones that are in place are generating energy. So as far as technological obsolescence, it would be the next solar farm that's built would be more efficient and most probably just take up less acreage.
Okay, thank you very much.
Hey, Commissioner, if I might follow up, Mark's the finance guy. I'm just a lawyer. But this act does every 20... That one, so I'll be brief. No, but this act does allow for a reset every 24 months. That's, I think, to your point, if technology evolves, if avoided costs, go up, go down, every 2 years, we come back before you and have this discussion again in a proceeding.
Thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. Actually, Commissioner Howard went where I was going, but I want to, before I get back to that, I want to follow up with each of you where Commissioner Irvin was questioning you about, I think about the independent consultant that this act allows the commission to employ. And just to follow up right at the end where he was, in your opinion, I think the way, Mr. Golden, particularly the way you answered the question, in your opinion, in that role, this consultant or expert firm, if you will, or group, since they're not under, as you said, probably didn't envision them being under oath and subject to cross up here on the stand, they would essentially function, in your opinion, just like any other technical advisory staff person we have, and engineers, accountants, or economists that we have here on staff, or that we might have here on staff at the commission. And it would just be an advisory role for us. And again, that final, as Commissioner Irvin said, that final, how we use that, or that final decision would rest with us. In other words, that group or that firm should be treated just like we do another staff member here at the commission. Is that right?
So I think you're spot on. I think it's our belief that no different than Joseph or any of the other fine commission staff out here, that's the role that they would play. Look, I've been involved with the PSC for a long time, and I understand, the limitations, again, of staffers and personnel shortages and that kind of thing. And so by allowing for this, they are advising you, they are issuing their report, you give deference to it as you see fit, along with everything else that is in the record. But it's no different than Mr. Melcher's wouldn't be subject to cross or direct. That's my opinion of how this, and I think the legislature would have specified that they're under oath and that they are subject to cross-examination had they wanted to.
Well, thank you for that clarification and for your exchange with Commissioner Irvin about that. Back to where Commissioner Howard was going, and not to go down the depreciation path a little bit, but, and I know he said you're more a finance person, I think, Mr. Wesson, but if you could get technical with me just a minute, since we certainly haven't seen this play out over 40 years. I know you reference these larger tracts of land that Johnson Development owns, and how many acres it would take to have 75 megawatts. I think you said around 600 acres.
Yes, sir.
What, after 40 years, can be done with that project? We look at nuclear generations that gets relicensed for another 20 years. We look at hydroelectric generation assets that get relicensed periodically by FERC. Other things go on with hydro facilities as well. Some don't keep them in the portfolio, some do.
all these facilities, and of course, we know what's happened with many of the coal facilities in South Carolina, but what would happen from a technical standpoint and with those facilities after they've reached their useful life? And also, does it matter the size of these commercial size generation facilities?
So at that point in time, at the end of the life, you still have an interconnection to the grid. You could negotiate a new PPA and repanel with new technology the same site. If you came to the conclusion from some reason that that was not what you want to do, say technological obsolescence at the end, our intention is to plant trees, just like we're doing now. We'd be able to just put it right back into pine plantation.
Do we know that is technology, I guess, far enough along that you know that that's the time that you would have to repanel? Do you think the panels you have now could go longer, or do they think they might go shorter, less time? What is the, I guess I'm getting real technical with you on.
There's a degradation in the panels over time. They will produce each year they produce a little bit less energy. So at that point in time, you can look at and say, I have energy being produced at not much more incremental cost than my maintenance that you have every year. Or I can invest new dollars and use the same land and infrastructure to put new panels that would create more energy, and it'll just be a cost-benefit calculation that you'll do further on down the line after your PPA is over, because you've got an obligation to deliver that energy.
Is the degradation accelerated on the larger 75 megawatt?
Yes, sir.
There's no acceleration in that because of the.
It's just each panel. You just have lots and lots of panels on 600 acres.
Well, thank you. That's all I have, Mr. Chairman.
Thank you. As long as you're not close to pine trees, right? Back them off and get that sap. Commissioner Hamilton.
Thank you, Mr. Chairman. Gentlemen, I think most of my questions have been answered, but I'd like to thank you for being here today. It's been very informative, and as we start on this path, we're going to need to hear from a lot of people. Thank you for being here.
Thank you for having us.
Thank you, Commissioner.
Thank you. Commissioners, any other questions? Okay, we appreciate y'all being here. I know with 3659, you've followed us, I'm sure. We've had a lot of people by turning into our live stream. We've been keeping check on numbers, and they've been pretty substantial through all these deliberations. And we've started off at a fast pace on trying to get ahead of this, and which I like, frankly, and I think it's we're finding the nuances of the bill as we go along. And of course, Mr. Golden, you've been involved with the advisory group, so we've I think that's going to all be a good thing for all of us. It's for us. It's going to be an interesting time to be able to, through this legislation, use the consultants, and I know that there's going to be a real formula to using marginal cost and the PPA and everything, and the methodology, how that gets worked out as to how this works best for everybody in this state. So we thank you for being here today. Appreciate your presentation. If there are no further questions, we are adjourned.